This video concerns the employment law developments we're expecting in England and Wales in 2021, and for the most part these will also apply in Scotland and Northern Ireland too, though there may well be some small regional variances. Now, we enter 2021 in a pandemic. I'm sitting today in a completely empty office. Normally in my HR department we'll have all of these chairs occupied, the phones will be ringing, staff will be talking to each other, we'll be discussing issues, but as you can see the office is completely empty, and this is the same as offices up and down the country at the moment. But employment law continues to roll on, and in January, 1st of January, already gone past now obviously, the transition period for Brexit will already have ended, and we'll have a new immigration system in place. Those Europeans and Swiss nationals who are already here on New Year's Eve have until the end of June to apply for settled or pre-settled status. But new arrivals wishing to live and work here, wherever they come from, will need a visa. And for the most part, an employer has to have a sponsorship license to be able to sponsor someone who wants to come across and work in the UK. We'll cover that in a separate film in the next couple of weeks because it is necessarily quite complex and it would make this video too long if I tried to cover it now. From the 1st of February, HMRC will begin publishing the names of employers who have claimed the coronavirus job support scheme payments, the CJRS payments, since December. And they'll also publish how much each employer has claimed. Probably no big deal, but it might be if certain employers may have claimed money they shouldn't have done, or perhaps they've claimed money for employees who continued working. So it's going to be visible. If we've claimed money against the CJRS scheme, it will be published from the 1st of February. On the 26th of February, consultations will close on whether to reform post-termination non-compete clauses. Now, this sounds a little dull, but actually it's quite a big deal. Many employment contracts, particularly for more senior employees or employees with access to commercial information, will contain non-compete clauses as part of their restrictive covenants. And it's one of those things that we talk a lot to employers about, is how to protect their business in the event that an employee leaves or goes off to join a competitor or wants to start a business competing with their former employer. Now, we're already hearing indications from the tribunal cases that we're seeing lately that lengthy post-termination clauses, the clauses that go on for a year, 2 years perhaps, or even more, are much less likely to be supported by the courts. But depending on the outcome of that consultation, we may well see that non-compete clauses in particular are ruled unlawful, or there might be a requirement for employers to pay employees for the period to which they want the clauses to apply. So if you don't want an ex-employee to set a business up competing with you for, let's say, 6 months, then it may well be that the consultation requires us in the future to pay that employee for 6 months of the clause. We won't know, but we'll find out towards the end of February when that consultation is due to conclude. The 1st of April, we have, as usual, the new national living wage and the new national minimum wage rates. We've made a separate video about that, so I won't go on and say very much more about it, other than to remind you that from the 1st of April 2021, the new full rate, the national living wage rate, will apply to all those over 23 or 23 and over. Currently in 2020 it's 25 and over, so the age is coming down for the full rate. On the 6th of April 2021, IR35 will apply to the private sector. Now, IR35 already applies to the public sector, and it concerns how a person working for a company should be taxed and pay their national insurance. At the moment, the duty is on the individual. So if you hire a contractor, you put them on a contract for service. It's up to the individual to prove that they are in fact a contractor and not an employee or a worker or something called an off-payroll worker, which is another type of taxable worker. Under IR 35, the burden for proving the status of that person will shift to larger employers. So not the smaller end of employers, but to the medium and large employers. And there are definitions of what a small, a medium or a large employer is for this context. On the same date, the 6th of April, we're also going to see new statutory rates come into force, statutory sick pay, rates for family leave, national insurance limits and so on. 6th of April is always the date that that changes, and we'll publish more on that again in due course. And on the 30th of April, the CJRS, the furlough scheme, is expected to come to an end. Obviously that's been extended a couple of times by government so far. Could it be extended again? I guess it depends on the rollout of the vaccine programme as much as anything else. Looking further into the year, on the 9th of November, the Supreme Court will work on whether part-year workers' holiday should be capped at 12.07% of their working time. Now, 12.07% is the traditional formula that employers who provide minimum holiday, 28 days, 5.6 weeks in the UK, apply to calculate a part-time worker's wages. But there's long been a debate about whether that's appropriate for people who are not so much part-time all the way through the year, but who work only parts of the year. So that could be term-time workers, for example. And that pretty much wraps up our collection of events that we're expecting in 2021. No doubt there'll be an awful lot of stuff that we haven't and don't expect, but we'll keep you updated with that as we go.